I wish we could all meet in person. We had the same session at the Bloomfield Hills Library day before yesterday, and it was very well attended. And I know that not everybody is near us here. Some people live too far to join for an in-person meeting. The only difference is that you can raise your hands in the in-person workshop and ask us questions, and I get to pick on you to see what your situation is and have a question answer session. The reason we are meeting today for this important informational meeting is because I started special needs planning 34 years ago. And many of our earlier clients who have been our clients more than 20 years, a lot of changes have taken place in your lives. But today we want to discuss a major law change that took place that I believe requires all of you to take another look at your personal planning and especially focus on special needs planning. So I'm going to share the screen here and focus on this presentation. And let me see if I get this. I hope you can all see this. And you already know my partners, Eleanor, Mehul, and Wesley, who is our young associate. And we are all well trained in special needs planning. We know the laws very well. Many of you work with them on a regular basis, and I know most of you as well. So we want to start with, let's take a look at, you may be familiar with what your planning is, where you are currently, what your documents are all about. You have a home, it probably looks like this. You have a home that's held jointly, and then when you both pass away, you have a quit claim deed or a ladybird deed that takes the house and puts it in your trust. This box is your trust. You all have a revocable living trust, which pretty much holds your non-retirement assets. Your home is a non-retirement asset. When you both pass away, it's going to go in that trust, unless you have a different plan that we will discuss later. So the beneficiary of your employer-provided life insurance, if you are still working, or you have personally purchased life insurance for your spouse or your other children, is held in this trust. Your non-retirement assets are also held under the registration of your trust. And this particular trust, the surviving spouse is usually the successor trustee. The husband and wife's joint trust, they're joint trustee on this trust. At the first death, the surviving spouse gets to be the manager or the successor trustee and has rights to use the income and principal of this trust. You also created a separate stand-alone trust for your child with special needs. A special needs trust is often known as a discretionary trust because the language in the trust says the trustee can use their discretion and use the income and principal to supplement the government benefits and maintain a quality of life for the child. Many of you have purchased life insurance for this particular trust on you, on the parents. And when you both pass away, this particular trust is going to be funded with the proceeds of the life insurance. And if you remember, one of the reasons we recommended this product is because not all the parents are going to have enough assets that last their lifetime, as well as have plenty for other children, as well as the special needs trust. So a life insurance has allowed you to create a new asset on a leverage basis. And the most important benefit of this asset is that it's income tax free. So when the money comes in, the trustee will use the income and principal for the benefit of the beneficiary of this trust. when the special need person passes away, if they happen to have children of their own, which occasionally happens, the assets are held in trust for their children. Otherwise, it goes to the other heirs, typically their siblings or the siblings' children, or it may go to the charity. Now, some of you also, instead of having a joint trust, may have two separate trusts. I also want to take a pause here very quickly. There is a question answer button at the bottom. If you have any questions, please feel free to type it in. At the end of the session, one of the panelists will bring up their question and I will be happy to answer. If not, please jot down your question and email it to us later tonight or tomorrow at our email address, and we'll be happy to call you or email the response back to you. Going back to this, many of you have a husband's trust and a wife's trust, depending on if there is any estate tax liability possibly coming up in the future, then the assets have been separated. Now, since the last tax law change, the exemption, an asset that you can leave behind for your children without estate taxes, has grown from $3.5 million to $11 million and up per person. So unless and until you have more than $10 to $20 million of estate, majority of the people will have one trust, but some people had two trusts to begin with, and they have carried it on. You still have the home held jointly, and upon death, the house will go to the trust of the last of the spouses to die. The retirement assets, the primary beneficiary is the spouse, because the spouse can take the deceased spouse's retirement assets and roll it over into his or her. And then you may have named your other children, your non-special needs children, as beneficiaries. In the two trusts, when the first spouse dies, the surviving spouse is the successor trustee, can use the income and principal for the maintenance of the spouse, vice versa. And when they both pass away, there is tax language there, but when they both pass away, the other children get some assets, and some of the assets will go to the special needs trust. In addition, there may also have been a life insurance. So that is your current plan, and I'm sure you all agree and probably recognize what your plan is. What has happened since you did your plan? What kind of changes have you seen or we see in our clients? Number one is you may have retired since you did your planning and now have some health challenges of your own, and you have to think about your own life planning. Your health matters, where you're going to live in the future if you cannot take care of yourself or your spouse, and how are your other children going to handle your health situation, in addition to the special need person that's either living at home or you are involved in your son or daughter with special needs day-to-day life. Many of our clients are experiencing that. Your special needs child may now be facing the aging process as well. In 1992, I had done planning for a family for their daughter, Sue. Sue is my oldest special needs surviving client. She is in her mid-70s now. Of course, at that age, her parents have passed away, her only brother has passed away, and her cousin is the trustee. Unfortunately, she has also run out of money, so she is not in the best shape health-wise or financially. And there's a lot of health issues. She had cancer, her jaw was removed, but she is still alive. Your other children may or may not all be near you. I have two daughters. One lives in Chicago, one lives in Portland, Oregon. A lot of her friends, their kids are not around. If your children are nearby, you're fortunate, because you will need somebody to help you make your health decisions but also as you age, without having all the children nearby, the child who is here gets a lot more responsibility. This year, we have heard from many successor trustees how overwhelmed they are feeling with the responsibilities they have, and they don't mind doing what they have to do for their brother or sister or the parents, but on top of their own lives, their work, their children, they are unable to keep up with the paperwork that's needed for Medicare or Medicaid planning and doctor's visits and so on. It gets to be quite a bit. I don't know what your situation is, but this is what we are finding among our clients. I wish I could ask you in person to raise your hand. How many of your children, adult child with special needs, are living at home with you? Some of you still are working and you're younger, you're managing this, but this is the single most challenge that we have when we know that your adult child is living at home with you. The problem is residential facilities and caregiving are major concerns and the number one crisis, especially after the pandemic. For whether it's for the elder population who are not well at home, looking after themselves, or they may not have health, good health, but they also have an adult special needs, a child living at home, and they all need some kind of care and they're not able to manage. But the elder people, even if they have assets, they can have somebody coming to the house if the money is not an issue to help them with their day-to-day caregiving, but they don't feel like they can leave the house because they have the adult special needs child living at home with them. And it's very hard for them to find a stable and safe residence. In Michigan, we now have community mental health does not support group homes anymore. We have had 2 or 3 situations where the adult son or daughter had been living in a group home under the license of adult foster care, AFC homes, where there are 6 people, up to 6 people living in a home, and maybe a family, a couple is handling their home. But they are getting older. The caregivers are getting older who had the original license. In one of our client situation during the pandemic, she said, I cannot handle it. So the daughter, after living there for 6 years, had to move back home with the parents, and the parents were not prepared for this. They thought that they had found a permanent home for their child. They were very relieved to have that happen, but now the situation has reversed, and this parent is having a tough time finding another alternative because that's a crisis. So when I tell you you need to do something about it, I know you may not have the right solution, but please think about it, whether you can um, continue to work with the community mental health or the local ARC to see what the solutions are. Come together with the other families if they have an adult child also that's compatible with your son or daughter to see what you can find. But it's quite possible, like many of our clients are saying, that they ultimately would like to have their own home available for their adult child. And we'll talk about that. What are the ramifications of that? You may be a sibling or a relative, family friend acting as a successor trustee. In our Bloomfield Hills workshop, because we have mentioned that please let your adult child who is going to be the successor trustee join in this meeting, because they need to hear what their responsibilities are going to be. They need to be familiar that what they have to do, what are the chores, what are the responsibilities, but they also need to be prepared with the fact that before they become the trustee of their brother or sister, they may have to deal with medical issues and caregiving issues for you as parents as well. Some of you only have one child who has special needs. You are relying on friends, siblings who are your age, or nephew and nieces, again, they need to be brought under the umbrella and picture to educate them on what they have to be doing, what is their responsibility. So what I'm saying is that you probably come to the office for your review of your investments. Eleanor, Mehul, Wesley, they're all asking you the right questions for the planning. But let's just take a look at the big picture. What are the things that we worry about when we revisit your plan? Number one is, are you financially secure? It's been a while since you retired. It's been a while since you have had any increases in your estate. Most people have seen market fluctuations, their expenses going up. Maybe their other children have needs, or maybe you have had to redo your house. There could be many reasons where money has been spent. Will your estate deplete if you need long-term care? This is also another big concern. There's a 70% chance that one or both of you may need long-term care. What is the plan? How are you going to pay for that? Is it going to be paid from the assets that you already have? Are you counting on some of the assets to go into the special needs trust? What is the plan if at all both of you need help or care? Who is going to be leading the care of the other spouse? I was with some of my friends yesterday on a book club meeting, and they were talking about two couples they know. The husband has Parkinson's and the wife has dementia, and their only son, who is a physician, lives in New York, and he comes here once a month and has to depend on friends and family to look in. This is a very, very difficult situation for many people. Now, I know that you're thinking that, Minoti, this is all doom and gloom. Do I really want to be part of this presentation? Because I want to hear what the solutions are. But let's see what they are. The most important thing is, don't take it for granted that everything is going to be okay. You have to be in the planner's seat and say, I know I can identify my problems. Now just let's focus. Can secure planning lead us to anything that's possible in terms of a solution? Maybe we can, but maybe you know your situation better, your family, your adult children. It's very important that you have some very heart-to-heart and open discussions on this. Has your special needs adult child needed more financial support or less? Many people will say, the SSDI money that my son gets, it's usually okay. And then we challenged one couple and say, can you start jotting down everything that you're spending? And it turned out that they were spending more money than they had thought. That is important because you may still be around another 10, 15, 20 years. There's inflation. And we are not trusting that the government will not alter the plans or make changes in the programs that your children are taking advantage of at this time. 34 years ago, when I started to do the workshop, I said the same dialogue, that I don't always trust that the government will be responsible for 100% welfare of your child. And that is coming out to be true. And now we look at the budgets everywhere. And I don't know why, but Medicaid is the first thing that they talk about, can we reduce? And remember, Medicaid is also the asset base for the elderly people. And our elder population is rising. And when they don't have the money to take care of their long-term care, it's the same dollars that helps them, the same dollars that is actually allocated for your child with special needs. Is the special needs trust funded with life insurance, or is it going to be funded with your retirement assets? We are finding that a lot of people, a chunk of their estate is made up of their IRA money. So are you thinking about leaving any of the IRA money to the special needs trust? Or is it going to, or do you have decent amount of money outside of your retirement assets, because that's one thing that Secure Act is going to address when we get to that. How involved is your successor trustee in you and your child's life planning matters? Again, I'm repeating this. Do they live near you? How much do they know about your assets, your legal documents? And have you listed what you expect them to do? How many of you have actually created what we call the letter of intent? We have always advocated that you have to have a letter of intent for your successor trustee, because when your other children left home, they always visited their brother or sister, they called, but they really don't know what's happening on a day-to-day basis. Have you documented everything? Their abilities, inabilities, where are they living, what are their favorite foods or medications or allergies or change of doctor, change of medication, where are they working, if at all? Were they able to maintain the job during or after the pandemic? What is their health situation? Somebody will have to step in your shoes. What are they going to rely on? Only the documents that you have created. What is their, how are you helping them to do their job? Have you reviewed your life insurance for the special needs trust since you purchased it? Some of you bought the policy 25 years ago, 30 years ago, 20 years ago, or even 10 years ago. We have to make sure that you run illustrations again, because either the policies were whole life policies that pay dividends, but the dividends are based upon the market interest rate. Only in the last year, the interest rates have gone up again. But for a number of years, the dividends were very low. So has that impacted the life insurance or not? You will not know that unless you run the illustration. Many of you have universal life policy, and there may have been a rider that says the guarantee benefit until age 90 or 95. 30 years ago, none of the insurance companies ever thought of extending the guarantee beyond 90. Today, we are running illustrations up to age 105. I'm going to India this year because Mehul's grandma, my mother-in-law, is going to be celebrating her 100th birthday. I've had two clients, both people died in 2007. They were both 107 years old. So people are living longer. The policy has to last that long. So running new illustration is very important. So let's talk about what the Secure Act is all about. In order for me to explain to you Secure Act, let me refresh everybody's memory about what the laws were about leaving retirement benefits. The Secure, SECURE, the government comes up with very fancy names or acronyms, setting every community up for retirement enhancement. It became the law in 2019, but there was a second part of it that became the law a year ago, last year in December. So to tell you in plain language, in December 2002, a law changed in favor of individuals who had IRA. That is the year. Before that, if you had an IRA and if you left it for your children, the taxation was calculated in the year that the parents died, and the children, when they inherited, they would pay the taxes over 5 years. But that law changed, and the law became that when the children inherit the parents' IRA, they can stretch it over their life expectancy. And instead of paying taxes upfront, they can stretch the tax paying period for the remaining of their life. So for example, if your son is 50 years old and you are leaving behind $500,000 of IRA, before 2002, that would be subject to $200,000 in income taxes paid over 5 years. But later, after 2002, if somebody left $500,000 and they had the remaining life expectancy, then they would take about $17,000 to start with, because let's say at age 50, you had 30 years of remaining life expectancy. So you can take all upfront, but why would you do that? You don't want to have to pay $200,000 taxes, because you can only take out each year 1/30th, 1/29th, 1/28th. So you take out about $17,000, $18,000 the first year and pay taxes only on the amount that you take out. That was the stretch. But you know what government does? They sometimes will give you and then they will take it back from you. So in 2020, the Secure Act changed the rule again and said when your children receive the IRA, they have to take it over just 10 years, not 5 years, not the remaining life, but just in 10 years. So when you did the planning, most likely you were assuming you were going to give the retirement assets to your other children because they have the rest of the life to take it, and it was more tax efficient to do that. Now they're taking it in 10 years and they'll be paying a lot more taxes. The only person when you pass away who receives the IRA will not be paying upfront taxes or in 10 years. Number one is your spouse. Number two is a minor child. And number three is a disabled person. And if the disabled person has a trust, the trust can inherit a retirement asset in a much more favorable way than your other children. Okay? So then, what does that mean? If you want to now leave, so we say that you have to go back on the drawing board and see how you want to divide your assets. And if you decided that you want to leave some portion of your IRA in a special needs trust, then your existing special needs trust will not work. It needs to have a separate paragraph, which is called the see-through language, that will allow the IRA to inherit, the special needs trust to inherit the IRA and stretch it over the child's life expectancy. And any funds that remains in the trust upon the death of the child then can either it's coming out of the trust and pays high taxes, or it can continue for your other adult children, and they also have to pay taxes on that over a period. Now, many of you may have thought that I really would like to leave money to some charities upon the death of my child. Now, if at all this was a retirement asset, in the past, even without the stretch language, IRS did not allow a charity to inherit an IRA from the special needs trust. The reason is IRA has to be given to anybody who has a measurable life expectancy. A charity doesn't have a measurable life expectancy, but now under the Secure Act, that is allowed. So anybody who has just one child, a special needs child, and say, I want to leave money to my other nieces and nephews, or maybe my siblings if they're still alive at that time. But upon the death of my special needs child, I really would like to give some money to maybe Autism Alliance or maybe Friendship Circle or any other nonprofits that has been very meaningful entity in your child's life, then you can now do that. But your document that was created for these reasons, it needs to be amended or restated. Okay? So what to consider when you fund a special needs trust? We know that in most cases, what you have done is you have to relook at the total needs of the special needs person. Think about and assume that the need is going to be greater than what you're looking at today. Don't assume that just because your son or daughter is managing with SSDI alone, or maybe you're only spending another $4,000 to $5,000 a year. Trust me, when your child ages, and then there are other issues coming up, having a trust with decent amount of funding will definitely maintain a quality of life for your son or daughter. So you have to estimate what the total needs of the adult child is going to be. And then you have to think about what assets are available for funding the special needs trust. Did you buy the life insurance? Great. You have a tax-free guarantee of certain amount. Do you also wish to leave some amount of trust money, which is your after-tax money? And or are you considering leaving a portion of your retirement assets? What about real estate? We recently have been doing planning for a client, and this person has a building, rental property, and a couple of other properties. And we told her that we do not want the special needs trust to inherit those rental properties because they are a little bit larger amount. So she also wants to leave the same building to the other children. So do you see what's happening? A daughter is now partners with the special needs trust that owns a portion of the building. Not a good idea. It gets to be very complex. You need to keep just simple assets so that it's easy, either generating income. I mean, we're talking about stocks, bonds, annuities, mutual funds, cash, CDs. Those are more desirable assets rather than a portion of a business or a portion of a part of the real estate or a building rental property. Tax implications, leaving life insurance versus retirement investments to a properly drafted trust, given the Passing Secure Act makes it complicated, but it can also work well if there is life insurance. I have a drawing at the end of this session to show you how those assets inside the trust all cohabited and how to visualize how it can all work together. Reviewing the trust documents created before 2020 or 19, because many attorneys, what they did is, if they created the trust document in 2019, even though the clarifying act of the first part was not established until 2020, many attorneys already added the stretch language in the 2019 documents. But if your trusts were created before 2019, and if you feel that the life insurance that you have left for the child is not enough, or for various reasons you want to leave a portion of the retirement asset because that is your biggest asset, then you must consider revising the trust document. Some of you may have worked with attorneys in the past that may have retired, or we may not be working with them anymore for various reasons. So when you come for your meeting, or all these things is making you a little bit anxious and you want to see us right away, let us know that so that we have reviewed your trust document and come up with options even before we see you, okay? So let me show you via drawing how it looks. Before 2020, when the first spouse dies, the IRA went to the surviving spouse. Then when the second spouse died, child A and child B got IRAs that they could stretch for the rest of their lives. The special needs trust also got life insurance, and a portion of the IRA, although it says here stretch IRA, it wasn't the same. It was given to them, but they had to take it in X number of years, not like the life expectancy, okay? Now with the Secure Act, when the husband and wife, the parents both pass away, child A and child B will get their IRAs, no stretch, and they have to be paid in 10 years, including Roth IRA. That law is also applicable to Roth IRA. But the special needs trust can get the life insurance if you have planned it that way, along with the stretch IRA money. So now one of the questions that comes up, that if you feel in your overall calculation that the life insurance and a portion of the IRA is more than enough for your special needs trust, but your other children, you are also leaving the responsibility of their special needs sibling. Perhaps if the life insurance is large enough, maybe you can give 10 or 15% to the other children, because they can then take the tax-free proceeds of the life insurance and use that to pay the taxes that is due on the IRA money. So you're repositioning your assets among your children so that they're all benefiting from the tax-free provision of the life insurance, and having the special needs trust stretch it. Hopefully it's more tax efficient. Okay. So how does Secure Act impact your existing plan? You need to review your overall financial planning here. Is the special needs trust the primary, or is it the contingent beneficiary of your IRA? The special needs trust will need to be revised to add the see-through language, which all the special needs attorneys know how to do that. Review the funding of the special needs trust. Is the money that you have left or thought about leaving, is it enough? So day before yesterday, when this topic came up, and I said, if you find out that what you have allocated for your special needs child is not enough, you want to leave a little bit more in favor of the special needs child. One parent says, well, wouldn't that offend my other children? Well, it may, because in many families I have seen that even though the other children love their special need brother or sister, they have often grown up feeling and having a sense of resentment or feeling neglected because the parents have focused so much on raising their special needs child. And now, if you say that you're going to get less and your brother or sister in the trust is going to get more, the buried feelings often surface, and I've seen that happen. So it's really a family counseling session, laying out the cards straight. This is what's happening in the system. This is what your brother and sister are going through. You are able-bodied, able-minded, you have a good job, you have a good family. We are directing a little bit more in the special needs trust, but when your sibling passes away, anything that's left is going to be yours. So you have to re-look at all your assets, what your other children are doing, and what is likely to be the need of your special needs. And I would urge you to guess that there's going to be more need than what you think. Okay. Your other children will pay higher income tax on the inherited IRA. But some of you may say, you know what, that's okay. They still have an inheritance. So what if they have to pay taxes? Sooner or later, you are paying the taxes also. But include other children as beneficiaries of the life insurance. That's a strategic planning and reshuffling your mix of assets there. So let's pretend that this is the special needs trust and you both have passed away. Most of you have a revocable special needs trust. As soon as you both pass away, the trust is going to become irrevocable. No more changes are possible, and the successor trustee steps in. Immediately when you call an office, now the trust is going to be a separate tax-paying entity, and it uses a new tax identification number. And as soon as that happens, we tell you that there's going to be life insurance proceeds or other inheritance coming in. Or go ahead, go to the bank and open a checking account under the name of Mr. And Mrs. XYZ successor trustee of Johnny's Special Needs Trust. that is going to be the title of the account. And then you're going to file the life insurance claim. And then the money first goes into the checking account. If you have had a trust account with investment, then your estate is most likely to be liquidated, or your children, let's say you have a large position in Apple stock, and your other children are saying, don't cash it in, keep it for us. I mean, we will not advise that way because we just want step up in basis and all those kind of things, but that's besides the point. But the non-retirement assets and the life insurance, all of the cash will be invested. So now you have an account here. The registration is the trust. You have a checking account in the name of the trust also. So life insurance proceeds and non-retirement investments are going to be designed after your advisors have discussed with you what is the income need of your brother or sister. You also have left an IRA here. Let's say the IRA is worth $300,000 in this trust, and your sibling, your child with special needs is at that time, let's say 55 years old, with a remaining life expectancy of maybe 20 years, hypothetically. So when you leave $300,000, it's going to be divided by 20. So the first year, because that's the remaining life expectancy. So the first year, the trust is now going to have a required minimum distribution. Many of you are taking that yourself. So when you're talking about stretching, you're talking about required minimum distribution that the IRA has to give it out. The $15,000 that's coming out here is deposited in the checking account. And you're not telling them to withhold the taxes at this time. I'm showing here a home. Many of you have expressed that, we cannot really find any safe place, and our son or daughter will be devastated if he ever has to move out of this house. This is his secure place, safe place that he or she has ever known. And so we are going to leave the house to him. Now, Medicaid allows a person with disability on Medicaid to own a house, okay? Even though the law allows it, not all things that the law allows are practical. We don't want Johnny to own a home because down the road, his successor trustees or siblings may say, gosh, this is too expensive to maintain. And expensive, not just money-wise, but just looking after it. Or the neighborhood has changed and this is no longer a safe place, so we want to sell the house. So if the house is under Johnny's name, it's allowed by Medicaid, but when you sell the house, and if it's worth $150,000, Johnny gets the check. It's $148,000 more than the $2,000 that a special needs person on Medicaid is allowed to have. So then they will be out of Medicaid until that money is put in another home. So the more practical thing to do is, if this is going to be the future home, your home is going to be the future home for your son or daughter, then you want to deed it to his special needs trust. And the house will be another asset in the trust itself. Now, you may think this house is too much space for my son alone. And you turn to the government, the community mental health, and say, can you find two other person who are going to be compatible to my son or daughter? And can they move in here? And then we can have a caregiver to look after them. Each of the person who is in there is getting X number of dollars from the community mental health for looking after them. Now, when your son or daughter does not own the house themselves, but the trust is owning the home and they live here, they are actually tenants of that house. They are renters of the house. So a portion of their SSDI will go into the trust on their behalf to pay the rent. The rent is going to be collected in this checking account, the two other people who are in this home will also pay rent from the Social Security, which is going to be held in the checking account. So now, in this situation, the trustee, your other children, are also landlords suddenly, okay? Or you can have a management company, but that money is helping them pay for the property taxes, utilities, and annual maintenance. So now, let's say that we are trying to determine $15,000 RMD has gone into this checking account. And you find out that year that your son with special needs traveled to California to see his sister who lives there, or the caregiving that was provided from the Medicaid just wasn't enough because of his health situation. So the trustee had to hire a private caregiver. And you find out that the expenses, the money distribution that came out of the trust, the checking account, was about $20,000. So that 20,000, well, 15 of that was just RMD. So the RMD was used up for the benefit of the child. Okay. So what happens is, if at all your son or daughter needed only $5,000 and the IRA distributed $15,000, we have a problem here. Because when you and I file a tax return, we don't fall under the highest tax bracket of about 40% until we make $500,000. But this trust has to make only $13,000 and it will be in the highest tax bracket. So while IRA is a good asset, but if all of the required minimum distribution is not spent by the beneficiary, the trust will end up paying high taxes. But let's say in this case, the person needed $20,000. If it was left in the trust, then it's highest tax bracket. But when it is used up by the beneficiary, then the trust will give a K1 for the $22,000. Some of the money came from IRA and other money was coming out of the investments done with the life insurance and non-retirement assets, which is subject to capital gains. This is subject to ordinary income tax. Capital gains is 10%, 15%, or maximum 20%. All of that is written up. A K1 is a tax document, just like your 1099 or W-2. But when an irrevocable trust gives out income, it comes in the form of a K1. Your accountant will need your help, the trustees' help, to determine how much money came out and how much, what was it spent for. Remember, this trust can spend money for things that the government does not cover. So if you have a private caregiver that's not provided by the government, then that's a legitimate expense. A travel, anything that is not covered by any medical insurance, you have to pay out of your pocket. That is going to be what the trustee does. House maintenance, yes. So all of that will go on the beneficiary's 1040, but their tax bracket is going to be so small, very little. So the tax is not going to be the most important thing when the taxes file under their name. This is how the trust is managed. We manage a lot of them because in the 34 years that I have been doing this, a lot of parents have passed away. The insurance came in, the other assets come in, and now people are considering whether they should be putting some IRA money in there or not. Okay, so I'm going to stop sharing the screen now and see what questions you have. If anybody has, send any questions in the Q&A, or maybe they want to send an email, but it's gotten more complicated. And we have families who want to leave the assets, real estate, but they also want to have the same asset go to their son or daughter. A partnership is very difficult to manage. Simpler solutions are needed to be found for this. Liquid assets are the best in the trust to manage. Some of you have more than one child, and I know you're definitely leaving your home for them. And so also seek out the help of your local ARCs and ask them and be in communication with them regarding housing matters. The community housing network can also help, but during the pandemic, they have kind of become very quiet because they know that housing has become a very big challenge. Okay, so I wish we were all in person so that I could see your raised hand and answer questions for you. But if you have any questions, email us, or there are two questions I see here.
From Mr. No, is it possible to have a link to this recording so that we can take our time and consume this information? The answer is yes. Yeah.
It'll take a little while by the time it's all transferred, but we will email it to you.
From
okay.
The second question is from Miss Hillary Morris. Her question is, does Roth IRA in see-through SNTs requires RMD?
Typically, it also requires RMD, but because it's tax-free, if you take it all out, there is no question asked. But you should have the language anyway. The way we look at it as advisors, let the trust be a chicken soup in terms of language. If you have the language, if you don't use it, it's not going to hurt you. But if you decided later on that I want to leave some money from IRA, the language is already there.
Those two are the only questions that we have.
Anybody else? I'm glad that you joined us. We are here to help you. It may have confused you more, but we are here to clarify it. So allow us to help you. But don't sit too long. Please go ahead and make changes in your legal documents and decide on housing. We have seen things happen suddenly in client situation, in parents' illnesses. And if you have not read my book, I urge you to do so. I hope you know that I've written a book. It's called Beyond a Parent's Love, and it has the nuts and bolts of the planning, but also many examples of true stories of the planning that I have been involved in. So I wish you all well and good luck with all your planning.
Bye, everyone.
Thank you.